Welcome to It's No Accident, a podcast about the challenges of personal injury and wrongful death law in Florida, one of the nation's most complex legal environments.
You'll hear compelling stories about real cases from our law firm in Tallahassee that will help you better understand your rights and protect yourself from the negligence of others.
I'm Mark Nani.
And I'm Jaeson Hamola.
And this is
It's No Accident.
All right, so obviously, when the kind of cases we handle, whether it's, car wrecks or falls or any type of injury cases, injuries don't discriminate in terms of they happen to really young people and they happen to middle-aged people and they happen to old people, right?
Right.
We see clients of all different ages. And I know recently you had a mediation with a gentleman who was on the older side, and, having like a really young client might present some challenges, but also having like a more elderly client can also present its own different challenges as well. And I think you had some of those kind of come up recently in that case, right?
Yeah, and it was more about the conversations leading up to mediation and some of the things that some of the arguments you hear from the defense attorney when you're negotiating the case. When you're dealing with an elderly client, it presents some issues that you might not necessarily see with somebody that is in their 20s, 30s, 40s. Anybody that's really under the age of like 70.
Mm-hmm.
When you start getting to the age of 70 and older, you start to see some issues that pop up that you might not see with other age demographics. And I would say, the main thing that I see and the main argument that I see from defense attorneys is, pre-existing conditions.
Sure.
If I've got a client that was involved in a car wreck and they've got neck and back issues and, they might have a herniated disc, it's not difficult for the defense attorney, once they know who this individual's medical providers are, to subpoena the records from the client's past medical providers, get those records, and look through, the last 20 years of medical treatment for that person. And honestly, it's not that hard for them to find neck and back pain. Sure. for an elderly individual. It's just something that happens over time. But with that being said, I have clients all the time that are living active, fulfilling lives, and, they're retired, they're playing golf, they're riding their bikes, they're traveling, they're doing things with their spouse or their loved ones or their grandkids, lifting their grandkids up, doing all of these things that you would think somebody enjoying their lives as an elderly person would be doing. Mm-hmm. And then they get into a wreck and they're like, I can't, I can do those things now, but it really causes me issues. And then you bring the claim and you start talking about these things, and lo and behold, 5 years before the wreck, they were going to their primary care doctor and saying, I worked in the yard a little bit too hard and my back hurt. And, come to think about it, it's been aching for the last 6 months to a year. Mm-hmm. And what can I do about it? And they might get sent to pain management. And they get going down this road where they're getting medical treatment for a neck and back issue or any kind of medical ailment. And then they get into a wreck and it aggravates that condition. And now you're dealing with an argument from the defense that, it's not related to the wreck, so we're not paying it.
Exactly.
So what are some of the things that you do in that situation to help combat that argument?
Exactly. Well, yeah, exactly. And it's really twofold. So it's like you're saying, like they're going to try to blame whatever's wrong with you on your pre-existing conditions, not on this wreck, right? And so that's something we got to deal with. And it's also just, I think, kind of like you were just saying, in that kind of a situation, when you have a client who's maybe elderly and has, just lived a long life, like you said, you're bound to have some neck pain and back pain over the years. It's important to try to help make sure that person remembers the prior instances they've had, because they're going to get their deposition taken. They're going to get questioned about it. And if they, just not remembering it, I mean, it's not great. That doesn't completely kill everything, kill the case if they don't remember it, but it's a heck of a lot better if they do remember it.
Right.
Versus straight up denying it, saying, oh no, I've never had prior neck pain or prior back pain, but then it's in the medical records from 10 years earlier. That can really mess things up, right? And so it's trying to help people, think hard and think long, and when you're prepping for their deposition, to help them remember any of their prior issues they've had, which for part of that is, we get the prior medical records, right? Yeah. And we'll go through them and help remind them. And then for the separate issue, like you were saying of, the insurance company trying to blame everything on the pre-existing condition, the main way to deal with that, I think, that we usually use is to just embrace it, and say, like, yeah, this person already had prior issues. They were already kind of in a weakened state. They weren't, a spring chicken, so to speak. And so, it didn't take a whole lot for it to get it didn't take a whole, a super big impact or a hard wreck or a big fall or something to make it a heck of a lot worse,
Right.
right?
A 25-year-old spine reacts a lot better to a motor vehicle collision than a 75-year-old spine.
Exactly, right. And so it's kind of, they're trying to use it as a negative, and you kind of just try to spin it around to I mean, that's why I always look at it, kind of embrace it and spin it around to show it in a different light. The light that really is it's a lot worse to deal with a bad wreck if you already have prior issues than if you had no prior no prior neck pain your entire life, kind of thing, right?
Right. And you bring up a good point about trying to remember what's in your medical records. And, if it was 10, 15 years ago and you didn't remember complaining of back pain to your doctor, that's not so bad. But when you're in a situation where, 6 months before the wreck, you were in
Hmm.
the pain management doctor's office and you were getting injections, that becomes a problem.
Yeah.
That becomes a serious problem. So, one of the things we do is we try to talk to our clients, get the names of all their past medical doctors, get those records, look through those records before the deposition, and try to help refresh their memory as to what sort of treatment they've had in the past. And honestly, I would say in just about every case that we get prior medical records on for somebody, I would say there's at least one thing in those prior medical records where the person is like, I never said that,
Right.
or I had no idea that was in my medical records. I like, and they'll swear up and down, I honestly do not remember telling my doctor about that.
Right.
So it's really important to get those records, and it does go a long way. A little bit of prep of your client before a depot goes a long way, so they're not sitting there on the hot seat and blindsided by a record from a few years ago where they're complaining of back pain.
Yeah, absolutely. I mean, doing prep with a client for their deposition is hugely important. And I still sometimes get amazed where, if I'm talking to a client who's maybe had a prior case with, prior law firm and has gone through deposition before, and like, the prior attorney never prepped them at all, or the prep was like, 5 minutes right before it started. So it's like crazy to me, like, because it's such an important thing for these reasons, like you're saying, to go like help the person understand what to expect and what's going to come at them, but also help them, like we're talking about, going through the medical records and help them remember this kind of stuff, and just be ready so you don't, say something dumb and put your foot in your mouth, so to speak.
And you're exactly right. It's funny. I've heard so many times where I've had a client that's given a deposition in the past where I'm like, well, what was the prep like for that deposition? And they're like, well, I mean, it was like 5 minutes right before the deposition started, and the main thing the attorney told me was just tell the truth.
Right.
And that's fine. I do want you to tell the truth. That's great. That's great advice. But you get a client in a deposition, they think they're telling the truth because they don't remember what's in their medical records,
Hmm.
and that becomes an issue. So,
Right.
there's a lot more that goes into that prep than just tell the truth.
For sure. For sure. And so, also I think with, in terms of just, things are a little different with the elderly clients. I know in any of these cases, a big part of the settlement or the compensation is for future medical treatment and future pain and suffering, which, becomes a little bit different in terms of life care plans and stuff when you're talking about someone who's, 40 or 50 versus someone who's 80, right?
Right,
You know?
right. So yeah, a lot of people don't realize this, but there's actually, it's kind of morbid to think about it, but there's actually things called mortality tables that exist. They're put out by the CDC in the
Mhm.
United States, and you can actually look at these mortality tables and look at your age and your race, and it'll tell you what your expected span is.
Mhm.
And we use mortality tables in trials a lot to show the jury what the expected lifespan is of our clients, so that when we're arguing for future pain and suffering or future non-economic damages, we can say, look, this person's 40 years old. The mortality tables say they're supposed to live till they're 83. That's what we're going to base our arguments on as far as what we're asking you for in terms of damages.
Mhm.
Now, when you have an elderly client, the problem becomes, what if you got somebody that's actually lived past the life expectancy?
Right.
And I actually had a client recently that had lived past his life expectancy per the CDC tables, And it was funny because I've told this client several times, when I first met you, I thought you were like 65 years old. He was like, no, I'm 83.
Hmm.
And he just had that kind of personality where he was, he was active, he was joyful, he was living a fulfilling life, and he just didn't seem like somebody. A lot of times when you think of an 83-year-old, unfortunately, you're thinking of somebody that's got a lot of ailments and they're moving a little bit slower and things like
Right.
that. He was still golfing, he was still walking with his wife, he was still traveling, still doing all those things. And you look at the CDC tables, and they say that he probably should be dead already.
Yeah. Right.
So
Right. Which is an awkward conversation to have with him,
it
right?
is, it is. It's an awkward conversation. Um, but some of the ways, or the main way that I try to combat that is, a lot of times when you talk to these folks and they've surpassed the life expectancy on these tables, you start talking to them about their family history
Right.
and ask them, how long did your mom live? How long did your dad live? Do you have anyone in your family that lived to be 100? And what I'll find a lot of times is that these folks will say, yeah, I mean, my dad lived to be 96 and my mom lived to be 91, or vice versa. And they've got these family members that have lived
Hmm.
longer than what the life expectancy is. So
Right.
you can certainly make the argument that, look, we know that he's surpassed his life expectancy per the CDC, but that's just an average. There are going to be outliers, and based on his family history, we think he's probably going to live another 10 or 15 years.
Exactly. Yeah. Like, and I was just gonna say, like you just said, I mean, we use the life expectancy tables, but that's not the only evidence. You can
Right.
bring in other evidence, such as the family history and what parents, grandparents, brothers, sisters, like how long they've lived, right? And it's
Right.
just part of the evidence of it all. Um,
Their lifestyle.
right. That too, for
Yeah.
sure.
Yeah. I think it's, if you've got somebody that's exercising frequently and more active, you would tend to have a jury that would believe more that they're going to live a little bit longer than somebody that's bedridden and sitting on the couch all day.
Sure. And then I think sometimes you also, maybe more so at like if you're actually up at trial on a case like that with a client like that in front of in front of a jury, you get into, the thought process or the argument of, are all years of your life created equal, so to speak, in terms of maybe, having, if these are going to be your last 5 years of your life and you're going to be in terrible pain for those last 5 years, maybe that's worth a little bit more per year than if you were younger, right?
Right.
Just in terms of where you're at and end up being not having a whole lot of years left, right?
Right.
And like, the whole, you're supposed to be retired and enjoying it, not, you know, getting surgeries and taking pills and doing physical therapy the whole time,
Right.
right?
Right. They call them the golden years for a reason.
Right,
They're
exactly.
not they're not called the dark ages. They're called the golden years.
Right,
They're supposed
exactly.
to be, you've worked your whole life to get to the point where you're, financially stable and you're able to do the things that you've wanted to do your whole life. And unfortunately, sometimes people, they get to that point and then they get into a wreck, they get injured by somebody else, and it throws a wrench in what their plans were.
Mm-hmm. Yep.
This conversation continues and much more on the next episode of It's No Accident.